This is the brief on the ICC hearings against Rodrigo Duterte. We're cutting right through the legal jargon to unpack the historic International Criminal Court proceedings targeting the former Philippine president and his infamous war on drugs. First, the core charges. You see, the prosecution alleges Duterte orchestrated a widespread, state-sponsored murder campaign. It kind of functioned like a deadly top-down corporate strategy. They claim he started locally with the Davao Death Squad and then just rolled the whole shebang out nationwide once he became president. Second, let's look at the defense's strategy. Duterte's lawyers argue there's absolutely no smoking gun linking him directly to the murders. They claim his violent public speeches were just colorful political hyperbole, and that official police orders to neutralize suspects literally just meant lawful self-defense. But, you have to ask, can a head of state's violent rhetoric really be brushed off as just bluster when thousands of people actually end up dead? Finally, the victim's reality and the high-stakes detention debate. Victims' representatives counter that this was essentially a brutal war on the poor that completely devastated marginalized communities. Meanwhile, prosecutors are demanding Duterte stay in pretrial detention. They argue that his powerful political network and open, stated contempt for the ICC make him a massive flight risk, for sure. Ultimately, the ICC judges must now decide whether Duterte's iron-fisted governance was just tough talk or a literal license to kill.
This video synthesizes the evidence presented during the confirmation of charges hearing in the case of the prosecutor versus Rodrigo Duterte. The indictment includes 3 main counts. Count 1 covers the Davao mayoral period, involving 19 victims linked to the Davao Death Squad. Count 2 relates to the national HVT campaign, with 14 victims labeled as high-value targets. Count 3 involves barangay clearance operations with 45 victims through Project Double Barrel local executions. The adversarial framework involves 3 parties: the Office of the Prosecutor, or OTP, who argues the war on drugs was a state-sponsored mass murder plan. The defense claims the anti-drug campaign was a legitimate exercise, and deaths resulted from lawful self-defense. Legal representatives of victims argue state rhetoric created an impunity virus that traumatized communities. A key issue is whether the president's words were direct admissions of intent, the blueprint, or merely crusty language and political bluster, the elastic mouth. The OTP cites 20 speeches, including threats of execution. The defense cites 35 speeches, including official caveats. The interpretation of neutralize is disputed. The OTP uses an insider witness testimony that the term universally understood code for kill. The defense highlights that official documents explicitly state operations must strictly observe the rights of the accused, and that any violation is anodyne or simulated policing. Defining the civilian population is also debated. The OTP sees the targets as alleged criminals in the Philippines, satisfying the requirement for a directed attack. The defense views criminals as a shifting, random group, breaking the legal definition of a cohesive civilian population. The LRV refers to the targets as a war against the poor. The debate over the widespread and systematic requirement hinges on data. The defense points to 3,967 deaths versus 118,287 arrests, claiming deaths are a minimal percentage of legitimate operations. The OTP cites 20,322 total deaths, an average of 39.46 deaths daily, inferring state-sponsored killings. The pyramid of perpetration focuses on Article 25(3)(a), indirect co-perpetration. Duterte is at the apex. Co-perpetrators and handlers are in the middle, and hitmen and police are at the base. The defense argues there is no smoking gun of a direct order from Duterte. In the case of Mayor Espinosa and Raul Yap, the victims were killed while locked in a jail cell. The defense claims a legitimate shootout, with victims resisting a search warrant. The OTP shows evidence of Duterte publicly stating Espinosa should be shot on sight, and both victims were marked neutralized on an official list. The legal representatives of victims describe the impunity virus through a 4-step cycle. Step 1 is the rhetoric of the president. Step 2 is the action of emboldened law enforcement. Step 3 is the cover-up of falsified death records. Step 4 is the chilling effect on communities. The dual lens of governance presents 2 realities based on raw inputs, such as profane speeches and armed volunteers. The defense lens views it as legitimate statecraft. The OTPLRV lens views it as a criminal blueprint, utilizing state resources and plausible deniability. Regarding procedural reality, the suspect remains in pretrial detention pending appeals. 3 flight risk factors are weighed: the suspect's waiver of the right to attend, a massive political support network, and a petition to force his return. The ultimate stakes present 2 visions. The defense vision sees a politically motivated prosecution and asks for charges to be dismissed. The OTP and victim vision believes a trial is the only antidote to the virus of impunity. Duterte's final request was for a monument depicting him holding a gun.
Trying a former sovereign head of state before an international tribunal is a rare and highly complex procedural challenge. The mechanisms of global justice are designed to pierce the veil of domestic sovereignty, but doing so requires navigating intense evidentiary thresholds. That process unfolds here, at the International Criminal Court in The Hague. The defendant is former Philippine President Rodrigo Duterte. The charges are crimes against humanity, stemming from his administration's lethal anti-drug campaign. But before a full trial can begin, the court must hold a confirmation of charges hearing. At this stage, the prosecution does not need to prove guilt beyond a reasonable doubt. They only need to demonstrate that there are substantial grounds to believe the crimes occurred as charged. The proceedings pit 2 diametrically opposed realities against each other. The defense argues the administration executed a legitimate domestic law enforcement operation. The prosecution argues the state orchestrated a systematic, sponsored murder campaign. To move to a full trial, the pretrial chamber must adjudicate 3 specific evidentiary battlegrounds: the legal definition of the targeted population, the true intent behind the president's public rhetoric, and the statutory necessity of keeping him in pretrial detention. The first battleground centers on the chapeau elements of Article 7 of the Rome Statute. This requires the prosecution to prove the attack was directed against a distinct civilian population. The defense leans heavily on ICC precedent, specifically the El History case, to argue this standard has not been met. They argue that categorizing victims as suspected drug pushers creates a subjective, random, shifting subset of individuals. If victims are selected based on the subjective suspicion of street-level police, the targeting is random, not directed at a defined population. The prosecution and the legal representatives of victims counter this by citing the Kenya and Ntaganda precedents. The prosecution's case defines the target demographic by their shared socioeconomic status and geography. The evidence shows the victims overwhelmingly came from specific, impoverished urban communities with extremely limited social mobility. By consistently targeting these specific, vulnerable neighborhoods, the state demonstrated a highly systematic, non-random organizational policy. Resolving this legal paradox determines whether subjective street-level policing can be legally classified as a crime against humanity when the victims share clear demographic and socioeconomic boundaries. The second battleground tests how the court evaluates the criminal intent of a head of state through their public and operational rhetoric. The defense presents an evidentiary shield consisting of over 35 public speeches, where Rodrigo Duterte explicitly ordered police to only shoot suspects in lawful self-defense. The prosecution dismisses these speeches as a deliberate veneer of legality. They compare this to precedent from the International Criminal Tribunal for the former Yugoslavia, specifically the Mladic case, where military leadership frequently issued boilerplate orders to respect the Geneva Conventions, specifically to mask actual criminal intent. The dispute drills down into the specific language of Philippine National Police operational directives, focusing on the word neutralize in official memos. The defense, supported by testimony from former police chief Ronald De La Rosa, claims neutralize is standard law enforcement terminology that includes non-lethal arrests. The prosecution counters with operational evidence, the PRRD target list, and the precise tracking of high-profile victims like Mayor Rolando Espinosa and Raul Yap. This timeline reveals a clear chronological contradiction. On the official list, Espinosa and Yap were not marked neutralized when they were successfully arrested or transferred to jail. They received that designation only after they were killed in their cells. This highly specific, fatal application of the term contradicts the defense's claim of neutral intent. It indicates that, operationally, neutralize functioned as an administrative synonymous for murder. The ICC must decide if a sophisticated leader's paper trail of lawful caveats legally sanitizes the lethal, documented actions of their operational command structure. We turn now to the hard statistical data, specifically the numbers published in the Philippine government's 2017 year-end report. This chart visualizes the defense's mathematical argument, comparing 118,287 total arrests against the 3,967 operational deaths officially recorded. By pointing to this low ratio of deaths to total arrests, the defense concludes the police exercised institutional restraint, negating a systematic murder policy. The legal representatives of victims analyze these exact same 3,967 deaths, but through the strict lens of Philippine constitutional law. Under the Philippine Constitution's right to life, any state killing reverses the standard presumption of regularity. This legally forces the police to prove that self-defense was strictly necessary in every single instance of a casualty. The Philippine Supreme Court explicitly found that the administration completely failed to substantiate self-defense claims for these thousands of deaths. Despite nearly 4,000 acknowledged operational deaths, the Philippine Department of Justice only ever reviewed a maximum of 302 cases. Viewed through this legal lens, the data serves as a metric of total institutional impunity. The final procedural battle addresses the ongoing detention of Rodrigo Duterte pending trial. Under Article 58 of the Rome Statute, pretrial detention is maintained by establishing that the suspect poses a flight risk or has the capacity to interfere with proceedings. In this instance, the suspect's own domestic political maneuvers effectively guarantee his continued international imprisonment. Duterte submitted an official waiver to the ICC, explicitly stating he does not recognize the court's jurisdiction, and classifying his transfer to The Hague as a kidnapping. By formally lodging this defiance into the record, he legally signaled a refusal to comply with any conditional release. This perfectly satisfies the statutory definition of a flight risk. The secondary factor preventing his release is his powerful, active domestic support network. This network organized a campaign presenting 160,000 signatures to the Philippine Supreme Court, requesting a habeas corpus petition to force his return to the Philippines. When a suspect publicly defies the court and retains a robust domestic power base capable of facilitating extraction, they trigger the exact Article 58 parameters that compel a tribunal to deny interim release. We return to the procedural question driving this hearing. The pretrial chamber does not need to deliver a final verdict of guilt today. They only need to confirm if the socioeconomic targeting of a distinct population, an operational language of murder that overrides public rhetoric, and an established flight risk interlock to satisfy these substantial grounds requirement. The Chamber's ruling on these elements carries broader implications for the future of international criminal law. This case sets the precedent for prosecuting legally sophisticated heads of state who use statutory boilerplate and official bureaucracy to mask systemic violence. Prosecutor v. Duterte tests the ICC's ability to pierce the rhetorical armor of a sovereign state and hold its highest architect accountable for the statistical reality of the dead.
Today, we're diving right into the case file on the explosive proceedings against former Philippine President Rodrigo Duterte at the International Criminal Court. But this isn't just about the accusations. No, it's really about the evidence itself. A high-stakes battle where data, documents, and even charts are the weapons of choice.
All right, so here's our game plan. First, we'll look at the actual charges, then we'll get into the big question. Was this a systematic plan or just political tough talk? After that, we're going to decode a single crucial word: neutralize, which leads us right into a fascinating battle of statistics. And finally, we'll see what this all means for how you prove a case like this. Okay, first things first. We need to get a handle on the sheer scale of what's being alleged here. The charges against Rodrigo Duterte are, without a doubt, some of the most serious that can be brought before any international court.
And to really wrap your head around the gravity of this, you gotta start with this number: 30,000. Representatives for the victims claim that the so-called war on drugs resulted in as many as 30,000 killings. It's a staggering figure that really sets the stage for the entire case.
So the central charge, the big one, is crime against humanity. Now the key phrase here is widespread or systematic attack. This means the prosecution can't just point to individual acts of violence. They have to prove that these were all part of an organized state policy, not just a series of random, tragic events.
And that leads us straight to the first major clash in this case. Did all these thousands of deaths happen because of a deliberate, organized plan to commit murder? Or was something else going on entirely?
For the prosecution, their whole case really hangs on this idea of a coordinated plan.
They're arguing that an agreement was shared, right from the very top, to neutralize alleged criminals using violence, and that this plan was put into action all across the country.
But the defense, well, they paint a completely different picture. They say Duterte's fiery speeches weren't actual orders. They're basically calling it political hyperbole. Tough talk for the cameras, not a real set of commands for the police to go out and kill.
And this brings us to this really crucial legal idea called the causal nexus. Basically, the direct link between the words and the actions. The prosecution says, look, the overwhelming pattern of thousands of similar killings is the proof of the plan. But the defense fires back saying, nope, not good enough. You need to show us a direct order, a smoking gun, for every single one of the 49 incidents you're charging him with.
Now, you're not going to believe this, but this massive debate, a grand plan versus just tough talk, it might all come down to how you interpret one single, almost bureaucratic-sounding word that pops up over and over again: neutralize.
So here you have it, the two sides going to war over one word. The prosecution has insider witnesses saying, come on, everybody knew neutralize was code for kill. But the defense argues it's just standard police jargon, a term for arrest or self-defense that carries absolutely no criminal intent. And this fight over words, it spills right over into the numbers. This isn't just a legal argument anymore. It's a full-on battle of statistics, where both sides are using the very same government reports to tell two completely different stories. And right at the heart of this data war is this government document, the President Rodrigo Duterte list, or the PRRD list. It's basically a spreadsheet with thousands of names of so-called high-value targets. For the prosecution, this is Exhibit A. As one insider witness bluntly put it, the PRRD list is, quite simply, a dead list. Okay, but this is where it gets really clever. The defense takes the prosecution's supposed dead list and flips it on its head, using its own data against them. They point out that, hey, of the 4,817 people on this list, only 248 were ever officially neutralized. And they boil this all down to one very striking number: 5%. Their argument is, if only 248 people out of almost 5,000 were killed, that's just a 5% chance. And that, they say, proves that being on the list was far from a virtual certainty of death, which kind of undermines the whole idea that it was a kill list at all.
And this wasn't just in some legal filing, no. In a pretty wild moment in the actual courtroom, the defense didn't just talk about the numbers, they insisted on showing them. They literally asked the judges to look at data visualizations they'd made, bar charts and pie charts, to put the killings into perspective.
And this bar chart illustrates their main point perfectly. Using the government's own 2017 report, they show nearly 4,000 deaths. But right next to it, you see this massive, towering bar of over 118,000 arrests. Visually, the number of deaths just looks tiny compared to the scale of the overall police operations.
Then, just to really drive the point home, they pull out a pie chart. They argue that when you look at it this way, the deaths, as tragic as they are, represent what they call a minimal fraction of total police activity. Their story is clear. This was a law enforcement campaign focused on arrests, not just killing.
But, and this is a huge but, the victims' lawyers looked at those exact same government reports and came to a horrifyingly different conclusion. They pointed to another category in the data: homicide cases under investigation. When you add those 16,000 plus cases to the official police operation deaths, the total just skyrockets to over 20,000 deaths. That's an average of nearly 40 people killed every single day.
So, what does this all mean? All this back and forth over words, statistics, and charts leads us to the final, really fundamental question of this whole case. In a court like the ICC, what actually counts as proof?
What you're seeing here are two totally different ideas of what proof even is. The prosecution is building its case on the big picture, the data patterns, the insider testimony, the sheer weight of thousands of incidents. But the defense is demanding the opposite. They say stats aren't enough. They want a smoking gun, direct, hard proof for every single one of the 49 charges.
So let's just boil it all down. These are the head-to-head battles the court has to figure out. Who do you believe, the insiders or the official reports? Is a huge statistical pattern enough, or do you need proof for each person? Was it a direct order or just political hot air? And what does neutralize really mean? Kill or arrest? And that leaves us with this final really challenging question that gets right to the very heart of international justice. When you're dealing with a crime on this kind of massive scale, is the bigger picture, that undeniable pattern of violence, is that enough to prove it, or does justice demand a smoking gun for every single life that was lost?
And that right there, that is the core battle being fought at the International Criminal Court. The outcome isn't just going to decide one man's fate, it could set the standard for how we prosecute mass crimes for many years to come.
Over a 2-year period, thousands of civilians were killed during police operations across the Philippines in an aggressive national anti-drug campaign. The architect of that campaign, former Philippine President Rodrigo Duterte, is now the subject of pre-trial confirmation hearings at the International Criminal Court in The Hague. The court is evaluating whether to proceed with charges under Article 7(1)(a) of the Rome Statute, prosecuting these killings as murder, a crime against humanity. To prosecute a head of state, investigators typically look for a direct written order. In this case, the prosecution lacks a signed directive, authorizing the execution of drug suspects. There is no traditional smoking gun. Because heads of state rarely document their crimes in writing, international tribunals cannot rely solely on explicit executive orders. Prosecutors must instead prove that the institutional apparatus itself became a coordinated weapon. To bridge the gap between the executive office and street-level killings, the prosecution applies Article 25(3)(a) of the Rome Statute, indirect co-perpetration. This framework differs from direct ordering. It establishes liability when an executive uses the state hierarchy as an instrument to commit crimes. The core requirement of this charge is proving a common plan. The prosecution must demonstrate a shared, orchestrated criminal design among the president and top law enforcement officials. Proving a common criminal plan presents a severe evidentiary challenge when the official state documents governing these operations explicitly mandate compliance with human rights and the rule of law. The confirmation of charges hinges entirely on this friction. Will the ICC adopt the defense's strict textual reading of state policy, or the prosecution's contextual reality of how that policy was executed on the ground? The National Anti-Illegal Drugs Campaign was officially launched via Command Memorandum Circular No. 16 of 2016. Within this document lies a specific, controversial directive ordering police to neutralize alleged drug personalities. The defense anchors its strategy in textual formalism, arguing that the court must interpret this language exactly as defined by official state procedure. According to the Philippine National Police Operational Procedures Manual, to neutralize means to apply lawful restraint, execute an arrest, or use proportional force to stop unlawful aggression. The defense emphasizes that Circular 16 also contains explicit written instructions requiring operating units to monitor and report human rights violations. This relies heavily on the presumption of regularity, a legal standard assuming state officers act lawfully in their official duties, unless specifically proven otherwise. By isolating the literal text of the manuals, the defense constructs a non-criminal framework that legally insulates the executive from the killings committed by subordinates. The prosecution counters with the doctrine of contextual reality, asserting that international tribunals evaluate how words are interpreted and acted upon by perpetrators, rather than their abstract definitions. They argue that human rights caveats in police documents are frequently inserted as boilerplate text to establish plausible deniability. This evidentiary approach aligns with the precedent set at the International Criminal Tribunal for the former Yugoslavia during the prosecution of General Ratko Mladic. Mladic's military orders explicitly mandated compliance with the Geneva Conventions. The tribunal disregarded these clauses, recognizing that those exact orders simultaneously facilitated systemic massacres. Applying this precedent to the Philippines, the prosecution utilizes insider testimony confirming that within the hierarchy of the police force, the term neutralize was understood explicitly as an order to kill. This interpretation is corroborated by a massive volume of nanlaban, or fighting back, police reports. Officers filed identical, copy-pasted accounts after thousands of encounters. The prosecution alleges these reports were fraudulent, designed to claim suspects violently resisted, and thereby legitimize the high death toll under the guise of self-defense. International tribunals maintain the authority to disregard neutral administrative text when systemic operational patterns prove the text is masking criminal intent. Beyond the written police manuals, the operations were accompanied by highly public, incendiary speeches from President Duterte urging the killing of drug suspects. The defense dismisses these statements as political hyperbole and bluster, arguing they possess no weight as legal commands. The legal representatives for the victims reject this framing, anchoring their counterargument in the Philippine Constitution. Article 7 vests all executive power solely in the president. In this specific cultural and legal framework, a president's public exhortations are structurally binding on subordinates. Incident 13, the murder of Mayor Rolando Espinosa, serves as a primary, verifiable case study of this policy in action. The sequence began with President Duterte publicly threatening Espinosa, demanding he surrender over alleged involvement in the drug trade. Espinosa surrendered and was incarcerated. Shortly thereafter, the prison's security cameras were systematically disabled, paving the way for a coordinated law enforcement unit. Officers entered the locked facility and shot Espinosa dead. The resulting police report claimed the mayor violently resisted a cell search, necessitating self-defense. This represents the PRRD, the presidential target list. The definitive proof of intent lies within its own documentation. Espinosa's status on this ledger was not updated to neutralized upon his arrest or incarceration. He was marked neutralized exactly on the day he was killed. This targeted assassination dismantles the presumption of regularity, demonstrating precisely how rhetorical threats were translated into coordinated, state-sanctioned murder. The proceedings in The Hague represent a critical intersection of language, executive power, and criminal liability. The defense insists the court evaluate the state apparatus strictly by its written rules and procedural manuals. The prosecution argues the court must recognize how executive appointments, rhetorical cues, and systemic operational patterns override those texts entirely. Assessing institutional policy in international law requires looking beyond the confines of official manuals read in a vacuum. To evaluate a common criminal plan under Article 25(3)(a), the ICC must judge the state apparatus as a holistic mechanism of action, rather than an isolated collection of texts. The pretrial chamber's impending decision carries significant weight for international criminal jurisprudence. The ruling will establish the exact evidentiary standard required to distinguish chaotic domestic policing from state-orchestrated crimes against humanity. If textual cover-ups are accepted as an absolute defense, autocratic leaders will possess a legally sound blueprint to deploy legal boilerplate to permanently shield themselves from accountability for systemic violence.
Okay, so let's get right into this. We're looking at a really complex case before the International Criminal Court, and it all boils down to one central puzzle. How do you prove a world leader is responsible for thousands of deaths when you don't have a single signed order to kill?
Right off the bat, you've got rhetoric like this. This quote is at the absolute heart of the prosecution's case against former Philippine President Rodrigo Duterte. They're arguing these weren't just words. No, this was the green light for a massive campaign of violence.
But on the flip side, the defense says, hold on. They argue that we're talking about words. Yeah, maybe they're vulgar, maybe they're inflammatory, but words themselves aren't crimes. And this is really where the battle lines are drawn. And that brings us back to the core challenge for the prosecutors at the ICC. And it's the central question we're tackling here. If there's no paper trail, no smoking gun document, what does a case for mass murder even look like? How do you build it?
So first, let's break down how the prosecution is trying to build its case. You can think of it like they're forging a chain, trying to connect the very top to the violence on the ground, link by link.
Their entire argument is that this wasn't just random violence. Not at all. They say this was a systematic policy, a common plan that started way back when Duterte was a city mayor and then just exploded across the whole country when he became president. You know, it's pretty wild, but a huge piece of this legal battle comes down to the meaning of a single word: neutralize. It pops up in official police documents. The defense says, hey, this is just standard police jargon. But the prosecution? They say it was a code word, a wink and a nod, that everyone knew meant kill.
So how does the prosecution try to prove their definition is the right one? Well, they do something pretty clever. They bring in an insider, a witness who testifies point blank that in that world, eliminate and neutralize meant one thing and one thing only: kill.
The prosecution also argues that, look, this is how it's often done at the highest levels. They point to historical cases, like the Bosnian war crimes trials, where official orders had all this language about respecting human rights, even while horrible atrocities were being planned. It's plausible deniability, right? Built right into the system.
But the prosecution's case isn't just about interpreting words. They claim they have something much, much more direct. A witness, someone who allegedly heard an order for a killing come straight from Duterte himself, using his famous call sign, Superman. This is their attempt at a smoking gun.
Okay, so that's the prosecution's chain. Now let's switch gears and look at how the defense systematically tries to smash every single one of those links.
Their entire strategy is built on this one foundation. They say it again and again. There is no smoking gun. There is no direct, provable order from Rodrigo Duterte to kill any specific person. No document, no recording, nothing.
So they attack the case from every angle. Those insider witnesses, they call them vicious murderers, just trying to save their own skin. That link between Duterte's speeches and the actual killings, they say there's no causal nexus, no provable connection. And that harsh language, well, they argue it was just a tool to scare people into obeying the law, not a command to break it.
And the defense brings its own paper trail. They hold up official documents, like this command circular, and they ask a pretty simple question. If there was a secret plan to kill people, why would the official written policy explicitly order police to respect human rights? They say these documents prove the state's policy was in fact lawful.
Okay, so this brings us to a really crucial point. How does the law even hold a leader responsible for this stuff? Faced with this no smoking gun problem, the prosecution had to make a really specific and strategic legal choice.
Basically, there were two legal roads they could go down. One is command responsibility. That's where a boss is on the hook for crimes their subordinates commit if they knew about it and did nothing. But that requires proving a really clear chain of command. The prosecution didn't go that way. Instead, they chose indirect co-perpetration, arguing Duterte was the mastermind of a common plan. Now, the defense jumps all over this, saying the only reason the prosecution chose that path is because they knew they couldn't prove a direct order was ever passed down the line.
So what is this indirect co-perpetration thing anyway? Well, you can think of it like this. It's a legal tool designed for exactly these kinds of situations. It's for leaders who orchestrate crimes from a distance, using the big machinery of the state to get things done, without ever having to pull the trigger themselves. It's about being the architect of the crime, not the person who gets their hands dirty.
You know, behind all of these legal arguments and courtroom tactics, it is so important to remember what this case is really about. We're talking about thousands upon thousands of victims and their families.
The sheer scale of the violence here is just staggering. Now, the exact numbers are debated, but some of the reports that have come up in court estimate that more than 30,000 people were killed in this so-called war on drugs. Just let that number sink in. And for the families of the people who were killed, this trial at the ICC is everything. Their lawyers argue that the justice system back home in the Philippines offers them zero hope. They even quote a former justice secretary who basically admitted that the path to accountability there is completely blocked. And then there's this powerful, heartbreaking statement from the victims' lawyers. They argue that the children who were killed in these operations, they weren't just collateral damage. They weren't just caught in the crossfire. The argument is that they were targets too.
So in the end, this entire massive case really forces us to ask a profound question about power and words and accountability. When a leader speaks and violence follows, where do you draw the line? Where does rhetoric end and responsibility begin? And wherever the judges at the ICC decide to draw that line, well, that could set a major precedent for leaders all over the world.
Imagine a government report just lands on your desk.
Okay.
And it's this official internal document. It's reviewing law enforcement operations over, I think, a specific 16-month window.
Right.
You read through the statistics and you hit a number that just makes you stop breathing.
Because the numbers are staggering.
Yeah. According to the state's own paperwork, these police operations have resulted in nearly 4,000 deaths.
Wow.
And if you run the math on that, it averages out to roughly 40 state-sponsored deaths every single day.
Every single day.
Yeah.
Right. Now, if you are the defense attorney looking at this exact same piece of paper, you might point to the hundreds of thousands of arrests made during that same period and say, well, look at how many we arrested without firing a shot.
You'd say it proves restraint.
Exactly. But if you are an international prosecutor, you look at those same 40 bodies a day and say, this isn't policing. This is an industrial scale factory.
It's the ultimate paradox of state power, really. You are looking at the exact same data set, the exact same piece of official letterhead, and arriving at two completely mutually exclusive definitions of reality.
Yeah.
One side sees a tough-on-crime miracle, and, well, the other side sees a slaughter.
Which brings us to today. Welcome to today's deep dive. We are exploring a stack of raw, highly intense, and honestly incredibly dense transcripts straight from the International Criminal Court in The Hague.
The ICC.
Right. We are looking specifically at the pretrial confirmation of charges and detention review hearings for the prosecutor v. Rodrigo Duterte.
This is case ICC 01210125, for those keeping track.
Thank you, yes. Involving the former president of the Philippines and the global controversy surrounding his administration's anti-drug campaign.
Which the world really came to know as the war on drugs.
Exactly. And diving into this, it is a massive undertaking.
Oh, absolutely. The ICC is fundamentally different from a domestic court.
How so?
Well, we are looking at an institution designed to prosecute the gravest crimes of concern to the international community. So when you pull a former head of state into that arena,
the stakes are astronomical.
Right. Every single legal definition, every translated word, every statistical anomaly is fought over tooth and nail.
But before we go a single step further, I need to make something incredibly clear to you, the listener.
Yes, the disclaimer. Very important.
Because the source material contains highly charged political content, we are talking about fundamental issues of national sovereignty, severe human rights allegations, and incredibly polarized global politics. This deep dive will take absolutely no sides.
Not at all.
We are not here to act as a shadow jury.
Our mandate today is purely analytical. We're essentially holding up a mirror to the court record.
Right. Our mission is to unpack the factual, the legal, and the emotional arguments presented by the prosecution, the defense, and the victims' representatives exactly as they appear in the transcripts you provided us.
We aren't endorsing any viewpoints.
We are just conveying the original source material to help you understand the anatomy of a major international legal battle. We want you to see how these towering legal arguments are actually constructed and, just as importantly, how they're dismantled.
It's a fascinating process.
Okay, let's unpack this. What exactly is the former president of the Philippines being charged with? Because when you consume the global media coverage of the Philippine drug war, the headlines frequently cite tens of thousands of casualties.
What do you do?
But when you look at the actual charging document drafted by the Office of the Prosecutor, the scope of the case they are bringing to trial looks vastly different, doesn't it?
It does. And that discrepancy between the media narrative and the legal docket is the first major hurdle we have to clear.
Right.
The Office of the Prosecutor, or the OTP as they're called, has brought 3 very specific counts of crimes against humanity. Specifically, the crime of murder against Mr. Duterte. Just murder. But the numbers attached to these specific counts are highly targeted. They are not charging him with 30,000 murders.
So if count 1 is localized and count 2 focuses on high-profile targets, I imagine there has to be a mechanism that accounts for the street-level, everyday casualties we saw on the news.
Exactly.
So how do the 3 counts actually break down geographically and temporally?
Okay, let's trace the map the prosecution is drawing here.
Let's do it.
Count 1 focuses on 19 specific victims, a number which tragically includes 3 children.
Oh, wow, 19.
Yeah. The prosecution alleges these murders took place in Davao City between 2013 and 2016.
Okay.
Carried out by a group that has been widely referred to in human rights reports as the Davao Death Squad, or DDS.
And the timeline there is critical, right? Because between 2013 and 2016, Rodrigo Duterte was not the president of the Philippines.
He was the mayor.
He was the mayor of Davao City.
And that is the foundation of the prosecution's entire narrative arc.
Who?
They are arguing that Davao City was the laboratory.
The testing ground.
Exactly. It was the testing ground for a very specific method of extrajudicial law enforcement.
So that's count 1.
Then we move to count 2, which shifts the timeline to his tenure as president.
Okay, stepping onto the national stage.
Right. This count details 14 individuals labeled as high-value targets who were killed nationally between 2016 and 2017.
High-value targets, like cartel bosses.
These were allegedly figures higher up the narcotic food chain. or political figures, mayors, and police officials suspected of drug ties.
Got it. Which leaves count 3 to cover the broader population.
Correct. Count 3 encompasses 45 victims targeted in national barangay clearance operations.
And for those who might not know, a barangay is the smallest administrative division in the Philippines.
Yeah, think of it as a localized neighborhood or a ward.
Okay.
The prosecution alleges these victims were killed in neighborhood sweeps between 2016 and 2018.
Right.
So if you synthesize those 3 counts, the OTP is presenting a total of 78 specific victims detailed across 49 distinct incidents.
78 victims. I mean, you can see how a casual observer might look at that and think the prosecution's case is incredibly narrow.
It sounds small compared to the headlines.
Yeah. 78 victims doesn't equate to the massive human rights crisis described by the United Nations. How does an international prosecutor bridge the gap between 78 meticulously documented files and the allegation of a nationwide systemic bloodbath?
Well, the prosecution and the victims' representatives are explicit in the transcripts that these 78 victims are a representative fraction.
A sample size.
Exactly. In the realm of international criminal law, prosecuting every single alleged murder in a multi-year nationwide campaign is a logistical impossibility.
It would take a century to try the case.
Yeah, at least. So the OTP selects representative incidents, a cross-section of geography, victim profiles, and perpetrators to prove a broader systematic pattern of behavior.
Which makes sense from a resource perspective.
Right.
But proving a pattern of violence is one thing. Proving the guy sitting at the very top of the government apparatus is legally, criminally responsible for a specific bullet fired by a specific police officer in a dark alleyway. That's a monumental leap.
And this introduces us to the specific legal framework the ICC is utilizing.
Okay.
The prosecution is not arguing that Rodrigo Duterte literally walked into an alleyway and pulled the trigger on any of these 78 victims.
Right, obviously not.
They are charging him under Article 25 of the Rome Statute as an indirect co-perpetrator.
Indirect co-perpetrator. So that implies he didn't do the physical act, but he is just as culpable as the person who did because he orchestrated the environment.
Exactly. But it requires a very high, very specific burden of proof.
How so?
The ICC needs to establish what they call a causal nexus.
A causal nexus.
They must map out an unbroken chain of command, a flow of intent from Duterte's overarching policies down to the hitmen on the ground. The prosecution has to prove beyond a reasonable doubt that there was a mutually agreed upon common plan within the state apparatus, and that this plan had an inherent criminal element.
Wait, hold on. You're telling me they need to prove a mutually agreed upon plan, but they can't produce a single memo.
Yep.
Not one email from the presidential palace saying, commence the killings.
Not one.
If there's no paper trail, how is this different from just a bunch of rogue cops taking advantage of a tough-on-crime mayor's rhetoric to settle their own scores or shake down neighborhoods?
And that exact skepticism is the bedrock of the defense's counterattack.
Oh, I bet.
And they deploy it with absolute lethal precision in the hearings. The defense team openly mocks the prosecution's organizational charts.
Really?
At one point in the transcripts, the defense literally calls the OTP's visual aids cute.
Ouch.
Yeah. They point to this graphic the prosecution projected in the courtroom, a triangle or a pyramid.
Right. The defense calls it the Pyramid of Giza. They say, okay, let's look at your diagram. You have Rodrigo Duterte perched at the very top of this pyramid. And down at the very wide base, you have the actual perpetrators, the policemen, and the vigilantes pulling the triggers. Yeah. But you have no connecting lines.
Exactly. The defense argues that the apex Duterte slips completely off the pyramid because there is no smoking gun.
The apex slips off the pyramid. That's a great visual.
The defense is adamant on this point. They state for the court record that out of all these 49 specific incidents, the prosecution cannot produce a single reliable, corroborated witness who will testify that they received a direct, explicit, unquestionable order from Rodrigo Duterte to go out and murder any of those 78 specific victims.
No signed execution order.
None. There is no recorded phone call saying, take out this specific person in this specific barangay.
It's the classic organizational defense.
It really is.
And it forces us to look at how international law handles the realities of power. Because I'm trying to think of a parallel here. When we look at prosecuting organized crime or even massive corporate fraud, the person at the very top rarely leaves a pristine paper trail.
Right. Of course not.
A mob boss doesn't send a notarized letter asking for a hit. A corrupt CEO doesn't put in an email, please cook the books on page 4.
They'd be in jail instantly.
Right. They use layered communication, they use plausible deniability. So does international law just throw its hands up when a head of state is smart enough not to leave a memo?
What's fascinating here is how the prosecution attempts to build the exact bridge the defense claims is missing.
How do they do it?
The OTP argues that in cases involving top-tier state leadership, the absence of a written bureaucratic murder order is a feature of the crime, not a bug.
A feature, not a bug.
Yes. They rely on a mosaic of circumstantial evidence to prove that the unspoken mandate was entirely systematized.
What kind of circumstantial evidence bridges a gap that massive?
Well, the prosecution points to the mechanisms of state power rather than single pieces of paper.
Yeah.
They highlight the flow of logistics.
Like weapons.
Exactly. The provision of weapons, the allocation of discretionary intelligence funds. They introduce evidence regarding financial rewards.
Like paying for hits.
Witness testimony alleging that bounties were paid out per dead body, scaling up depending on the profile of the victim.
Wow.
They also trace the movement of human capital.
What does that mean?
The OTP highlights the appointment of specific personnel to key national positions, essentially tracking how loyalist police commanders from the Davao City days were promoted and moved up to the national level precisely to execute this campaign on a macro scale.
So promoting the guys who did it locally to do it nationally.
Exactly. But above all the logistics, to cement that bridge between the apex and the base, the prosecution relies on public statements.
The speeches.
Yes.
The public addresses, the midnight press conferences, the rallies. This really is the centerpiece of the entire transcript.
It dominates the conversation.
Both the prosecution and the defense are wielding Duterte's own mouth as their primary weapon.
The prosecution heavily leverages Duterte's public addresses to prove this common plan to commit murder. In their document containing the charges, they isolate 20 specific speeches.
20 speeches. And the rhetoric in those 20 speeches is intensely visceral.
It is.
We are talking about a 2015 televised interview before he even took national office, where he says, quote, "If I become president, you will all get wiped out."
Right.
Or they point to a farewell video, essentially a goodbye address to his constituents, where he speaks to a cheering crowd and says, quote, "Assuming I'm the one who killed all these people, it was for the Filipino people."
The prosecution's argument is that this isn't just colorful political rhetoric. It is a broadcasted statement of criminal intent.
A broadcasted mandate.
They argue he was publicly telegraphing to the entire national police force and to shadow vigilante groups that they had the ultimate green light.
Right.
And, more importantly, that they had an ironclad guarantee of presidential protection from domestic prosecution if they carried out the mandate.
Okay, but the defense's counter strategy here is fascinating because they don't deny he said those things.
They didn't run from it at all.
They don't claim it was a deep fake or a misquote. Instead, they embrace it and contextualize it. They scoured the public records themselves and found 35 other speeches.
That is a significant volume. It's a 350% increase over the evidentiary speeches provided by the OTP.
Right. And in these 35 speeches, the defense points out that Duterte explicitly and publicly gave lawful orders to the police.
Right.
He says things like, quote, "Do not kill if you are not in danger of losing your life." Or he reminds them to follow the Constitution.
The defense leans heavily into his established persona. They present Rodrigo Duterte not as a calculating architect of genocide, but as a uniquely abrasive populist.
A tough guy.
Exactly. They argue he was a man of the people who deliberately used coarse, vulgar, belligerent language to connect with the working class. His homespun theories, as the defense affectionately calls them, were pure political hyperbole. They were psychological warfare designed to instill terror in drug cartels and assert his tough-on-crime brand to the electorate.
So just words.
Just words. They were not literal, actionable, administrative, shoot-to-kill orders.
The defense asks a very pointed, almost theatrical question in the transcripts.
I love this part.
They ask, how many times did this president start a speech by throwing away his prepared, legally vetted notes and just rambling off the cuff for an hour?
Right.
They argue that doesn't show a crafty, calculated criminal mastermind methodically plotting crimes against humanity. It just shows a populist politician with a very loud, very unfiltered mouth who likes to sound dangerous.
Which forces the prosecution to introduce a concept they call the elastic mouth theory.
The elastic mouth. It sounds like a concept from a sociology class, but it's a crucial legal framework here.
It is. The prosecution argues that a savvy political leader can essentially speak criminal intent out of one side of their mouth, the side that tells the police to wipe them out and promises pardons,
Yeah.
while simultaneously sprinkling in legal caveats out of the other side of their mouth to maintain plausible deniability.
It makes me think of a corporate scenario.
How so?
Well, imagine a ruthless CEO pulling their sales directors into a boardroom and screaming, "I want you to destroy the competition by any means necessary, burn them to the ground, take all their clients, I don't care what you have to do."
Right.
But then at the very bottom of the company-wide memo, there's a boilerplate footer that says, "Please comply with all SEC guidelines and corporate ethics policies."
Oh,
If a sales director goes out and commits massive corporate espionage and the feds come knocking, the CEO just points to the footer and says, "Look, I told them to follow the rules."
the prosecution is arguing that Duterte's reminders to only shoot in self-defense are just the boilerplate footer meant to protect the boss.
That makes total sense.
That is an incredibly apt parallel. The prosecution actually compares this dynamic to the trials of Bosnian Serb army commanders following the Yugoslav wars.
Really?
They point out that those military leaders would routinely add boilerplate text to the bottom of their field orders that said, "Respect the Geneva Conventions."
Whoa.
It was an illusion of legality. It was a prepackaged insurance policy meant to be presented to an international tribunal years down the line.
But let's look at the reality of translating that.
Okay.
If a leader is globally famous for being hyperbolic, for exaggerating, for saying outrageous things just to dominate the news cycle, how can a panel of judges sitting in a pristine courtroom in The Hague objectively separate a metaphor meant to scare a local drug dealer from a literal murder mandate meant for the chief of police?
It's extremely difficult.
How do you litigate the difference between tough talk and a kill order?
That is arguably the most difficult question of this entire pretrial phase. And the way the ICC attempts to resolve it is by looking at how specific bureaucratic language is translated into physical action on the ground. We have to move past the televised speeches and look at the actual paperwork distributed to the precincts. A perfect example in the transcripts is the fierce debate over the word neutralize.
The word neutralize, this centers around Command Circular number 16 of 2016, right? Also known as CMC 16.
That's the one.
This was the foundational document. It was the official police mandate that formally launched the anti-illegal drugs campaign nationwide, which was branded as Project Double Barrel.
Correct. The text of CMC 16 repeatedly uses the word neutralization when referring to illegal drug personalities.
And the defense stands up in the chamber and says, "Look at this document. Neutralizes standard, boring, globally accepted police jargon.
Yes.
It means to lawfully arrest. It means to incapacitate a threat through legal proportional means."
They even quote the chief of police himself, testifying that neutralization explicitly meant to operate within the bounds of the law.
But the prosecution takes that exact same word, highlights it in red, and presents it as a smoking gun.
They do, because the prosecution doesn't rely on the dictionary definition. They rely on contextual translation.
Contextual translation.
Yes. They present testimony from insider witnesses, former police officers, and alleged death squad members who were asked point blank by investigators, when you received an order to eliminate or neutralize a target, what did that actually mean in the field?
And what did they say?
And according to the transcript, the witness answered with one word: kill.
Wow.
The prosecution argues that within the specific, hyper-violent ecosystem of the Duterte administration, neutralize was a universally understood euphemism for extrajudicial murder.
This clash over language is fascinating, but eventually, the arguments over semantics hit a wall.
They always do.
You can only debate the definition of a word for so long before you have to look at the bodies. And this brings us to the next major phase of the transcript, because even if we agree those speeches are incitement, or that neutralize means kill, words aren't enough to trigger an international tribunal.
Right. The ICC isn't a domestic murder court.
Right. To elevate a localized killing to a crime against humanity, there is a massive legal hurdle regarding who is actually being targeted. Which brings us to the chapeau elements and the definition of a civilian population.
The chapeau elements. The word chapeau is French for hat, and in legal terms, it refers to the overarching requirements, the umbrella that must cover a set of crimes before they fall under the jurisdiction of the Rome Statute.
Okay.
You can't just have a series of murders. To be a crime against humanity, there must be a widespread or systematic attack directed against a civilian population.
And the defense zeroes in with laser precision on that specific phrase. civilian population.
Yes, they do.
They mount a massive, fundamentally structural legal challenge here. The prosecution claims the target of these state attacks were alleged criminals or suspected drug pushers.
Right.
But the defense argues that alleged criminal is an entirely subjective, moving target. It is not a population.
It's a profoundly effective legal argument that cuts to the core of international jurisprudence. The defense points to established ICC precedent, specifically referencing the Al Hassan case in Mali and the Kenya situation.
What did those cases establish?
They argue that to be classified as a civilian population under international law, the group must possess objectively discernible characteristics. They must be identifiable by nationality or ethnicity or religion or political affiliation.
Right.
But how do you objectively define a suspected drug pusher? There's no official registry. There's no trial determining their status. It is a label applied retroactively after the bullet is fired.
Right. The defense argues that drug suspects don't share a physical trait. They don't wear a uniform. If the police officer pulling the trigger gets to subjectively decide in that split second who is a criminal and who isn't, then the targeting process is inherently random.
Chaotic.
And if the targeting is random, it legally invalidates the charge of crimes against humanity. You can't have a systematic attack directed at a population if you can't even define the population.
If we connect this to the bigger picture, the defense is trying to dismantle the entire architecture of the charge.
Right.
They are arguing that if the victims are just a random assortment of individuals killed by rogue cops settling personal vendettas or rival drug gangs wiping each other out, which the defense claims some insider witnesses actually admitted to, then there is no cohesive civilian population being targeted by the state.
It's just a tragic wave of domestic crime.
Which belongs in a Philippine court, not in The Hague.
But the victims' representatives and the prosecution refuse to let that characterization stand. They recognize that if the defense wins this definitional argument, the entire case collapses. So they come back swinging.
Oh, they respond by redefining the demographics entirely.
Okay.
The victims' representatives argued that the targeting was absolutely not random. It wasn't chaotic. It was terrifyingly precise.
How so?
They point out that the victims overwhelmingly shared very specific, objectively discernible socioeconomic characteristics.
They weren't just random citizens. They were impoverished. They came from marginalized urban communities. They lived in informal settlements.
Exactly. The Victims' Council argues this was a methodical, targeted war against the poor.
A war against the poor.
The people killed lacked social mobility. They lived in areas marked by severe poverty. The argument is that the method of the attack sweeping slums and low-income neighborhoods and the socioeconomic status of the victims define the population just as clearly as ethnicity or religion would.
And to prove the sheer scale of this targeting, the legal team makes a crucial distinction for the judges between the words widespread and systematic.
Yes.
Because the law says the attack must be widespread or systematic, but the prosecution argues this campaign was both.
Widespread is a quantitative measurement. It is about massive scale, thousands of bodies, geographical, spread across the entire archipelago over a period of years. It's the sheer volume of the bloodshed.
Okay.
And systematic.
Systematic, on the other hand, is qualitative. It's about the organized nature of the violence. It is the use of public resources, the mobilization of the police apparatus, the deployment of intelligence funds, and the non-accidental, methodical repetition of similar conduct across different jurisdictions.
And to prove this widespread and systematic nature, both sides end up looking at the exact same piece of paper to draw entirely opposite conclusions.
Yes.
This part of the transcript is absolutely mesmerizing. Both the defense and the prosecution rely on the Duterte administration's own 2017 year-end report.
It is the ultimate Rorschach test for this hearing. You have the official statistics laid out in black and white, and it becomes a battle over how to interpret the math.
So the defense puts this report up on the screen in the chamber. They point to the macro data. The report touts 118,287 total arrests for drug-related activities.
Right.
Next to that, it lists 3,967 deaths during police operations. The defense argues, look at the ratio, look at the pie chart. Out of over 100,000 police encounters, less than 4,000 resulted in a fatality.
It's a small percentage.
The deaths are a tiny fraction of the arrests. This proves the police were exercising massive restraint. It proves they were actively trying to arrest people, not executing a blind policy of murder.
It's a compelling statistical defense. But then, the victims' representatives look at that exact same data set.
Yeah.
They focus solely on that number, 3,967 deaths between July 2016 and November 2017, and they reframe the math.
And the mass they present is chilling.
They point out that 3,967 deaths compressed into that specific 16-month time period averages out to 39.46 state-sponsored killings every single day.
Almost 40 people a day.
Killed in police operations.
Yeah.
Officially acknowledged in a government report. To the victim's counsel, that doesn't prove restraint. When you have 40 bodies hitting the floor every single day, uninterrupted for over a year, it proves a massive, systematic, and relentless attack. It proves industrial efficiency.
And that number, almost 40 deaths a day, pulls us violently out of the sterile legal arguments about jurisprudence and chapeau elements and forces us to look at the ground-level reality. What does 40 deaths a day actually look like in a neighborhood? This transition in the transcript is palpable.
It really shifts the tone of the whole room.
Up until this point, the arguments have been highly technical, almost academic. But when the victor's representatives take the floor to detail the human toll, the entire atmosphere of the hearing shifts.
They are there to illustrate the visceral impact of the policies being debated by the lawyers. They are providing the bloody context for the statistics.
The testimonies they bring forward from the families and the survivors are harrowing. We hear a lot in the transcripts about the Nanloban narrative.
Yes. Nanloban is a Tagalog term that roughly translates to fought back or resisted.
Okay.
It became the ubiquitous standard issue justification on almost every police report for why a suspect was killed during an operation.
The default excuse.
The official line was a copy-paste scenario.
Yeah.
The police arrived to make a lawful arrest. The suspect suddenly pulled a concealed weapon. They resisted arrest, and the police were forced to fire in self-defense to protect their own lives.
But the victim's counsel paints a completely different, horrifying picture of these encounters. They detail a specific account of a young man sleeping in a shanty with his common-law wife.
Right.
In the middle of the night, men in civilian clothes kick down the door. The man is terrified. He knows what happens during these raids. So he strips himself completely naked to prove to these armed men that he is unarmed.
To show he has nothing.
He has nowhere to hide a weapon. He cries out, "Sir, I am clean!" And according to the testimony presented to the court, he was shot and killed anyway.
And the representatives make it clear that this is just one incident among thousands. They detail another operation where 3 men were killed early in the morning in a cramped apartment. The neighbors, hiding in their homes, watched as the bullet-ridden body of one of the victims was dropped out of a second-floor window.
Because the police couldn't navigate his body through the narrow doorway?
Yes. And the horrifying detail that haunts the transcript is that as the body hit the ground, the neighbors heard the victim cry out, array the Tagalog word for ouch. He was still alive when they dropped him from the window, and he was left to bleed to death on the concrete.
It's incredibly heavy to process, and the victim's representatives emphasize that the trauma wasn't just the violence itself, it was the systemic cover-ups that immediately followed.
Right, the aftermath.
The state machinery didn't just kill these people, it erased the truth of how they died. The representatives talk extensively about falsified death certificates.
This is a crucial element of proving a systematic cover-up. Families would receive death certificates for their loved ones who were clearly shot multiple times, bodies with visible bullet wounds, but the official cause of death documented by the medical examiner would be listed as pneumonia or sepsis or as sudden heart attack.
That is just, it's wild. And on top of that staggering indignity, these deeply impoverished families were being charged exorbitant retrieval fees by local funeral parlors. The victim's counsel suggests these parlors were in cahoots with the police, operating a morbid kickback scheme. And if family members dared to go to the police station to ask questions or demand an investigation into why their unarmed son was shot, they were frequently arrested on fabricated drug charges themselves just to silence them.
This ground-level reality, this vast chasm between the police reports and the grieving families, leads directly into one of the most contentious legal battles in the entire transcript. It's the clash over a doctrine known as the presumption of regularity.
This is a fascinating legal concept. How does a state function if it assumes its own police are lying? What is the presumption of regularity?
Presumption of regularity in the performance of official duties. It essentially means that if a commissioned police officer files an official report stating they acted lawfully, saying they arrived with a warrant, the suspect shot first, and they fired in self-defense, the legal system presumes that official report is accurate, unless concrete evidence is presented to prove otherwise. It gives the state the benefit of the doubt.
So the defense leans hard on this.
Did you?
They argue that it is the bedrock of law enforcement. They say you have all these thousands of police reports citing self-defense. You must legally presume the officers are telling the truth. The burden of proof is on the prosecution and the victims to prove that every single one of these thousands of individual reports is a fabricated lie. You can't just assume a massive conspiracy.
It's a strong procedural defense. But the victims' representatives, and they actually cite rulings from the Philippine Supreme Court to back this up, argued that the presumption of regularity completely evaporates the moment a life is taken.
Because of the Constitution.
Exactly. The Philippine Constitution guarantees the fundamental right to life. Therefore, the victims argue, when an unarmed civilian is killed in police custody, the presumption must flip. The burden of proof falls entirely on the police to prove that their use of lethal force was absolutely necessary, proportional, and lawful. You don't get the bureaucratic benefit of the doubt when there's a dead body on the floor.
So what does this all mean? When you zoom out from the legal doctrines, we are looking at a fundamental breakdown of truth.
A complete breakdown.
What happens to a society when the official paperwork of the state, the neatly typed police reports, the medical examiner's death certificates, the polished government data completely and entirely contradicts the lived, bloody reality of the neighborhoods?
It creates a bifurcated reality.
Yeah.
One reality exists in the filing cabinets of the Capitol, perfectly legal and justified. And another reality exists in the streets, characterized by terror and impunity. And resolving which reality holds legal weight, which reality the international community will recognize, is exactly why the ICC is holding this hearing.
But the defense doesn't just sit back and play defense. They don't just argue about jurisdiction or definitions. They go on a massive offensive.
Oh, they do.
Because the defense team understands that in an international tribunal, you aren't just defending the client, you are battling the entire narrative apparatus of the international community. They actively indict the ICC's process, the international media, and the human rights organizations that built the foundation of this case.
It's a classic, aggressive, and often very effective defense strategy in international law. You put the tribunal itself and its sources on trial. You question the objectivity of the entire institution.
The defense crafts a very potent, deeply patriotic counter-narrative of who Rodrigo Duterte actually is. They don't shy away from his tough image. They embrace it as a necessary virtue.
They paint him as a hero, really.
They do. They paint him as an honest, uncompromising leader who dedicated his life to public service. They remind the court that he saved Davao City from a violent communist insurgency in the 1980s, turning it from the murder capital into one of the safest, most prosperous cities in the region.
They argue that the national drug war wasn't a crime against humanity. It was a desperate, legitimate fight for national survival against international drug cartels that were actively poisoning the Filipino youth.
Right.
They argue that these cartels were armed, dangerous, and deeply embedded in local politics, and that without Duterte's uncompromising hand, the country would have devolved into a narco state.
And you have to acknowledge the philosophical weight of that argument. A head of state has a fundamental constitutional duty to protect their citizens from existential threats.
Absolutely.
But then the defense takes aim at the people telling the other side of the story. They claim that this entire ICC case isn't an organic pursuit of justice. It is the result of a loose collective of civil society and NGOs, heavily funded by Duterte's political enemies, wealthy tycoons, and Western institutions that don't understand Filipino realities.
They frame it as a coordinated, highly lucrative smear campaign. The defense lawyer specifically mocks the dramatic, sensational nature of NGO reports.
Yeah, this part was wild to read.
He points out to the judges that these organizations use evocative neon-lit photography of rainy crime scenes to manipulate the emotions of Western donors.
He actually jokes in the transcript that their reports have titles straight out of a James Bond movie.
Yes.
He cites NGO reports with titles like License to Kill or One Shot to the Head. The defense argues that these groups aren't objective investigators doing rigorous forensic work. They are political activists pushing a predetermined progressive narrative that international academics and European courts blindly echo without verifying.
This raises an important question about the nature of international justice, and it's a friction point we see constantly. Defense attorneys highlight the tension between domestic sovereignty, a democratically elected leader doing what they feel is necessary to protect their nation in a complex, violent environment, and global institutions located thousands of miles away in Europe, judging those actions through a sterilized theoretical lens.
And the defense gets incredibly personal with their attacks, aiming squarely at the former ICC prosecutor himself, Karim Khan. They don't just attack the evidence, they attack the man who gathered it.
Yes, the accusations against Khan in the transcripts are severe and highly unusual for their directness. The defense alleges that Khan had a predetermined crusade to nail Duterte long before the official investigation even began.
They point out a significant conflict of interest.
A huge one, if true.
Before becoming the chief prosecutor of the ICC, Karim Khan acted as private counsel for victims. And in that capacity, he had already interviewed a key witness against Duterte. The defense argues this completely contaminated the objectivity of the investigation. How can a man objectively weigh the evidence if he previously represented the people providing it?
And in a moment of sheer courtroom drama, the defense claims that Khan's preparation for this massive international legal undertaking was based in part on a book.
A book the defense dramatically calls a trashy piece of pulp fiction.
Titled Duterte Harry.
Duterte Harry. The defense uses this to suggest the entire prosecution is built on sensationalism, media clippings, and activist literature rather than objective, rigorous, on-the-ground fact-finding.
It's a concerted strategic effort to delegitimize the very foundation of the charges. The logic is simple. If the investigator is biased, the defense argues, the fruits of that investigation are poisoned. You cannot build a legitimate trial on a foundation of political activism.
Which perfectly sets the stage for the final and perhaps most legally bizarre phase of our depth dive. Because alongside the confirmation of charges, deciding if there is enough evidence to go to trial, the court also had to review the physical status of the suspect.
Right.
Which brings us to the debate over detention, defiance, and flight risk.
This is where the abstract legal theories crash into physical reality. The chamber had to review whether Mr. Duterte should remain in pretrial detention in The Hague.
Right, so let's establish the current reality of the transcript for our listeners.
Good idea.
As of the date of this specific hearing, former President Rodrigo Duterte is physically in pretrial detention at the ICC facility. The chamber is holding a mandated procedural review to decide if he should be granted interim release, essentially international bail pending his actual trial.
And the prosecution, along with the victims' representatives, are pounding the table saying absolutely not. They argue he is the ultimate flight risk. Releasing him, they argue, would be equivalent to ending the trial.
And their primary evidence for him being a flight risk isn't just that he has money or a private plane. It's Duterte's own defiant attitude. The man signed a legal waiver explicitly refusing to attend his own confirmation hearing. But it's not just that he didn't want to sit in the courtroom, it's the language he used in the waiver.
He stated plainly, in writing, that he completely and utterly refuses to recognize the jurisdiction of the International Criminal Court.
He didn't mince words.
No. He went so far as to claim that his arrest was illegitimate, that he was effectively kidnapped by international authorities, and that he was forcibly renditioned to The Hague against international law.
The prosecution argues the absurdity of the situation. How can a panel of judges grant bail to a man who tells you to your face that he doesn't respect your authority to hold him? It's an oxymoron.
Right.
If he doesn't believe you have the right to detain him, he certainly isn't going to voluntarily fly back to Europe for a trial.
Furthermore, the victims' representatives point to the massive political machinery back in the Philippines actively working to secure his release outside of the ICC's legal framework. This isn't just a suspect wanting to flee. This is a state apparatus trying to extract him.
They bring the receipts on this. They present evidence of over 160,000 supporters who signed a habeas corpus petition demanding the Philippine Supreme Court declare his arrest unconstitutional and force his return.
A habeas corpus petition essentially demands that a prisoner be brought before a court to determine if their detention is lawful. It's a domestic legal maneuver aimed at invalidating an international arrest.
Right.
And it's not just grassroots supporters. His own family, including his son, Congressman Paulo Duterte, are actively using their massive domestic political leverage. They are filing petitions urging the highest court in the Philippines to legally prohibit the national government from cooperating with the ICC in any shape or form.
So the prosecution is painting a picture of a man with zero respect for the court, backed by a rabid political base and powerful legislative allies, just waiting for the second he is granted interim release so they can whisk him away on a private jet back to Manila, surround him with loyalist security forces, and never be seen in The Hague again.
It seems like an open and shut argument for continued detention. But then the defense makes a move that completely subverts expectations and catches the chamber slightly off guard.
Yeah, this threw me when I read the transcript. The defense stands up and says, "Actually, Your Honors, we will not oppose the continuation of his detention today."
It's a brilliant strategic point.
How do they do that?
The defense clarifies that they have a completely separate foundational appeal currently pending regarding the initial decision to detain him. They are arguing that the arrest warrant itself was illegal. Because they are waiting for the appeals chamber to rule on that broader existential issue, they decline to waste their energy fighting the temporary procedural extension at this specific hearing.
It's high-level legal chess. They are basically saying, we aren't going to argue about bail today because we expect the higher court to throw out the entire arrest tomorrow.
Exactly.
But it leaves us with this incredible paradox. Let me ask you. If a suspect outright tells a court, "I don't recognize your authority, you kidnapped me, your laws don't apply to me," how can that court realistically grant them interim release without looking completely foolish and toothless?
Practically speaking, they can't. The mechanics of interim release rely on trust. Release requires conditions, surrendering a passport, checking in with local authorities, a sworn promise to return for trial. If the suspect explicitly states they view the court as an illegitimate, hostile entity, any promise they make is entirely hollow. It forces the court's hand to maintain detention simply to preserve the physical integrity of the proceedings. You cannot try a ghost.
Which brings us to the end of the transcripts and honestly the end of this massive, exhausting journey. We have covered an immense amount of ground today, from the slums of Davao City to the highest echelons of international law.
It truly is a masterclass in conflicting realities. We have watched two sides construct entirely different universes using the exact same evidence.
On one side, you have a prosecution team and desperate, grieving victims pointing to a highly organized, state-sponsored campaign of murder, verified by a trail of thousands of bodies and falsified death certificates in deeply impoverished neighborhoods.
And on the exact opposite side, you have a passionate defense team claiming this is nothing more than a political witch hunt, a global overreach by elite, out-of-touch institutions that fundamentally misinterprets a populist leader's tough guy, street-level rhetoric as literal orders for execution.
And I want to speak directly to you, the listener, for a moment. Because while this specific case is rooted in the history of the Philippines and the procedural mechanics of the ICC, the themes we've unpacked today feel incredibly relevant to almost everyone's experience with modern politics right now.
It touches on a nerve that is universally raw across the globe, the weaponization of language.
We live in an era where political leaders worldwide across the entire ideological spectrum are using increasingly violent, hyperbolic, and inflammatory language. We see it broadcasted on social media platforms every single day. We hear it screamed at political rallies and televised debates. Lock them up, wipe them out, crush the enemies, destroy the opposition.
It's everywhere.
This ICC case is the ultimate high-stakes stress test for that kind of rhetoric. How do we legally, objectively separate just words metaphors meant to fire up a political base or intimidate a rival from actual prosecutable criminal liability?
Where does the metaphor end and the mandate begin? If a leader speaks violently and their followers act violently, mapping the causal link between the podium and the pavement is becoming the defining legal challenge of our time.
And I want to leave you with a final provocative thought, something that wasn't debated by the highly paid lawyers in The Hague, but something we all have to grapple with as citizens.
Right.
If a leader's public bluster, their unapologetic, violent rhetoric, their promises to be a ruthless punisher, demonstrably leads to real-world deaths, even if they later claim it was just a figure of speech, at what point does the electorate that cheered for those words share in the responsibility?
It's a heavy question about the social contract.
If the crowd applauds the promise of violence, if they vote for the man who promises to fill the bay with bodies, does voting for the punisher make the public an accomplice to the punishment? Something to think about as you watch the news or scroll through your feed this week. Thanks for diving deep with us.
Welcome to the debate. In November 2016, a Philippine mayor named Rolando Espinoza was murdered inside his own jail cell.
Right.
Which is, a tragedy. But unfortunately, violence in prisons does happen.
Yeah, it does.
But here is the truly chilling part. On the exact same day Espinoza was killed in that cell, his name was officially marked as neutralized on a confidential target list kept by the President of the Philippines.
Oh, wow. So the paperwork perfectly mirrored the physical execution.
Exactly. It mirrored it perfectly. So today we are examining the intensely complex evidence and the legal arguments presented at the International Criminal Court's pre-trial confirmation of charges hearing.
This is in the prosecutor versus Rodrigo Duterte, right?
That's the one. We are looking at a massive, catastrophic loss of life and trying to figure out what the blueprints actually tell us. So the central question is, do the facts, the speeches, and the statistics establish substantial grounds to believe there was a systematic, state-sponsored policy of murder?
Meaning crimes against humanity?
Right. Or on the flip side, does the prosecution's case rely just, way too heavily on subjective interpretations of political rhetoric? Do they fail to establish the direct causal links that international law requires?
Which is a massive hurdle in these types of cases.
It is. So I will be taking the position that the evidence, which spans explicit public directives, the structural shielding of police, and a staggering volume of uninvestigated deaths, clearly demonstrates a widespread and systematic attack directed against a civilian population.
And I will be arguing that the rigorous evidentiary thresholds of international criminal law are simply not met here. Because, the prosecution relies on cherry-picked political hyperbole, they fail to establish a direct causal nexus to the specific charged incident, and they completely ignore the presumption of regularity in Philippine law enforcement operations.
Okay, so to understand exactly what the prosecution and the victims' representatives are trying to prove here, we have to look at the specific legal mechanism they are using. They aren't saying Rodrigo Duterte personally shot anyone on the street.
Right, obviously not.
They are building a case for indirect co-perpetration. This is under Article 25(3)(a) of the Rome Statute.
Right. And just for anyone listening who isn't an international lawyer, indirect co-perpetration is essentially the idea that you didn't pull the trigger yourself, but you built and controlled the machine that did. It's like a mafia boss giving a wink and a nod rather than, a signed execution order.
Exactly. But in the Philippine context, we are arguing it went far beyond just a wink and a nod. Because when the president speaks there, it is effectively national policy. And Duterte did not hide his intentions.
Well, he certainly didn't hide his rhetoric, that's for sure.
Right. We have his own direct admissions. Look at his farewell speech, where he explicitly stated, assuming I committed all these murders, it was for the greater good.
Yeah.
That isn't a slip of the tongue. It is the culmination of a heavily documented history that began with his oversight of the infamous Davao death squad. The prosecution argues he took that local blueprint from Davos and structurally implemented it on a national scale.
Through what was called Project Double Barrel.
Exactly. And the result of Project Double Barrel was thousands of deaths and, crucially, an almost total absence of mandatory investigations. When we see that absence, it establishes a definitive, unbroken pattern of state-sponsored impunity.
Look, I hear that, but you're relying really heavily on the idea that political speeches automatically translate into literal criminal orders. And let's be real here. International criminal cases simply cannot be built on political hyperbole or media narratives.
But the rhetoric wasn't just hyperbole. It was...
Wait, let me just finish the thought. Because we are operating in a strict court of law here, not the court of public opinion. The defense at the ICC successfully highlighted a massive, glaring evidentiary gap in the prosecution's case. There is just no smoking gun.
Well, a smoking gun isn't legally required if the circumstantial evidence is strong enough.
I know, but the gap is still significant. There is not a single direct order linking Duterte to the 49 specifically charged incidents of murder and attempted murder in the charging document.
Sure, but...
And the prosecution's narrative selectively relies on a highly curated list of just 20 speeches to prove criminal intent. What they conveniently ignore are the 35 other speeches where Duterte explicitly commanded his police forces to use force only in lawful self-defense.
Okay, but we have to look at the context of...
He literally said verbatim, "Do not kill if you are not in danger of losing your life." Furthermore, when you look at the macro-level statistics on the ground, they actually point to a functioning law enforcement system. You have over 118,000 arrests during this period.
I mean, arrests don't negate the deaths.
No, but compare the arrests to the fraction of operational deaths. Those casualties, while undeniably tragic, are the expected, harsh reality of attempting to dismantle deeply entrenched, heavily armed narcotics cartels.
I completely disagree with that framing of the rhetoric. Honestly, let's dig into the operational vocabulary used on the ground, because that's how policy is actually transmitted to the police. We have to look at the mechanics of Command Circular 16.
Which was the document that formally launched the anti-illegal drugs campaign.
Yes, and the prosecution points specifically to the term neutralize, which is used continuously throughout these operational directives. The evidence from insider witnesses explicitly defines neutralize not as a standard police arrest, but as a direct euphemism for murder.
But that's a heavily disputed definition.
But we don't just have to rely on witness theory for that definition. Look at the specific material evidence I mentioned at the start of the show, Incident 13. Mayor Espinoza and Raul Yap were marked as neutralized on the president's PRRD list on the exact day they were murdered in a jail cell.
Right.
They weren't marked neutralized when they were arrested and put in the cell. They were marked neutralized when they were dead. The paperwork mirrors the physical execution. That isn't hyperbole. That is policy in action.
I'm sorry, but taking a standard law enforcement term and injecting it with a nefarious hidden meaning is an incredibly weak legal foundation, especially when the drafting document actually contradicts that hidden meaning.
How does it contradict it?
Well, Police Chief Ronald De La Rosa, who drafted Command Circular 16, explicitly defined neutralization in a strict legal context. He testified that it meant knock and plead, bringing suspects in peacefully.
But the reality of what happened to Espinosa.
Let's look at the circular itself. It is not some secretive manifesto for a death squad. Paragraphs AE and AF of that very same circular explicitly mandate the strict observance of the rights of the accused.
Right, but
rights as enshrined in the Philippine Constitution and international human rights law. What the prosecution is doing here is relying on this novel and frankly unprovable elastic mouth theory.
The elastic mouth theory?
Yeah. The prosecution is essentially asking the chamber to assume that whenever Duterte demands lawful behavior, whenever he issues a written command to respect the Constitution, he is just lying to create a cover story.
Well, yes, that is the argument.
But whenever he uses explosive, colorful, violent slang, he is issuing a formal, literal state policy of murder. You can't have it both ways in criminal law. You can't just declare that the exculpatory evidence is fake and the incriminating evidence is the true policy without a direct causal link.
I think that is a fundamental misunderstanding of how state-sponsored crimes operate. The inclusion of legal caveats in official documents to mask a criminal enterprise is not a novel concept in international law.
Really?
Yeah, this is exactly what the ICC and other tribunals are designed to pierce through. Let me offer a direct historical parallel. Think about the veneer of legality we saw unspool during the ICTY tribunals covering the war in Yugoslavia.
But wait, Yugoslavia was a recognized active armed conflict. This is domestic law enforcement. That's a huge difference.
The context is different, but the mechanism of deception is exactly the same. Bosnian Serb army commanders, including General Mladic, consistently included boilerplate language in their written orders.
Instructing troops to follow the rules of war.
Right, instructing troops to, quote, respect the Geneva Conventions. They put it in writing, signed it, and filed it, while they were simultaneously coordinating horrific ethnic cleansing on the ground.
Okay, I see the parallel you're drawing.
The legal caveats Duterte included weren't genuine instructions for lawful behavior. They were built-in legal defenses. They were sprinkled into the documents to give his lawyers exactly the argument you are making right now.
I see.
When a mayor says, I will order your execution within 24 hours, and then thousands of people are subsequently executed without trial, pointing to a constitutional caveat in paragraph 8E doesn't magically erase the reality of the policy.
But the reality of the policy still has to be proven through a direct causal chain to the charged crimes. If you want to argue before an international judge that the 35 speeches commanding lawful self-defense are just a veneer of legality, you still have to prove the underlying secret order to kill.
Which the prosecution is doing.
But they aren't really, not for the 49 specific incidents listed in the document containing the charges. And here is where the prosecution's case really falters: their own witnesses.
What do you mean?
The crime-based perpetrators, the police officers on the ground, said things like, the PMP never said kill those people. They testified that the reason people were killed was because they were pointing guns at the police.
That's the standard police narrative, though.
But if the people pulling the triggers testify that they were acting in self-defense against armed resistance, you can't just wave that away and claim it's a structural cover-up, not without hard physical evidence linking it to the top.
Which brings us to the physical reality on the ground. Because if we are going to dispute the intent behind the speeches, we have to look at the scale of the resulting violence.
Okay, let's talk about the scale.
When rhetoric is ambiguous, the scale of the destruction reveals the true policy. We aren't just looking at 49 isolated incidents. Those 49 are representative charges to ground the case. We have to look at the Philippine Supreme Court's 2018 judicial notice.
You're referring to the government's own year-end report?
Yes. The highest court in the land recognized the Duterte administration's own 2017 year-end report, which cited a staggering 20,322 deaths related to the drug war.
That is a very high number.
It's massive. If you do the math on that timeline, it breaks down to an average of almost 40 deaths every single day. And the brutality recounted by the victims' representatives shows this wasn't standard by-the-book police work. We are talking about horrific, methodical executions.
Right.
We have testimony of a victim who actively surrendered, stripped completely naked to prove he was entirely unarmed, and was still shot dead on the street. We are talking about a bullet-ridden body dropped from a second-floor window, emitting a cry of, ouch, when it hit the ground, left to bleed to death in the dirt.
Look, those accounts are incredibly harrowing, and any loss of life under those circumstances is a tragedy. But analytically, as legal experts, we have to question the validity of treating broad, national statistics as definitive proof for the 49 specifically charged incidents.
But how can you ignore 20,000 dead bodies? If this was legitimate law enforcement acting purely in self-defense against armed cartels, why did the Department of Justice only review 302 cases out of those thousands of deaths?
Well, resources, for one.
But think of the justice system as a circuit breaker. Normally, a suspicious police killing trips the breaker, triggering an automatic proprio motu investigation to ensure it was lawful. What Duterte allegedly did was bypass the circuit breaker entirely, allowing the lethal current to flow unchecked.
But you are attempting to bridge a massive evidentiary gap with inference instead of proof. The prosecution is trying to prove a widespread attack to satisfy the Rome Statute, but they failed to produce the physical evidence required to substantiate mass coordinated executions.
The 20,000 bodies are the physical evidence.
But look at the defense's points regarding Count 1 in Davao. The prosecution claimed there were a multitude of bodies buried in a quarry, a literal mass grave. But when they actually dug up the remains, they yielded World War II Japanese soldiers.
Okay, that was one.
It's an embarrassment. Another witness claimed bodies were routinely thrown into the Davao Gulf, but the Gulf was never dredged and not a single executed corpse was produced from that water.
But the absence of bodies in a gulf doesn't invalidate the official death toll.
You cannot bridge the gap between 49 specific criminal incidents and 20,000 national deaths using NGO reports, especially ones that sport sensationalized James Bond-style titles like License to Kill or One Shot to the Head. Statistics and flashy reports do not replace the legal necessity of proving who pulled the trigger and who gave the direct order for that specific trigger to be pulled.
I'm just not buying that defense, because the legal standard for a widespread and systematic attack under Article 7 of the Rome Statute doesn't require dredging an entire Gulf, not if you have 20,000 bodies explicitly reported in the government's own official year-end report.
But the report categorizes those as operations, not murders.
The Philippine Supreme Court literally noted that the government's inclusion of these deaths among its accomplishments leads to the direct inference of state-sponsored killings. The state was actively taking credit for the body count on official letterhead.
Right, but
You don't need to dig up a mass grave when the police themselves are recording almost 4,000 drug personalities dying in official operations without initiating the legally required circuit breaker investigations for those deaths.
the systematic nature isn't just about the numbers.
The systematic nature is proven by the methodology. It's identical modus operandi across multiple towns and regions, targeting the exact same demographic, followed by the exact same failure to prosecute the officers involved.
Okay, but let's play devil's advocate here and shift our focus to the strict definitions within the Rome Statute itself. Because even if we accept your framing of the statistics, this is where the prosecution's case becomes fundamentally legally muddled.
How so?
Under Article 7, a crime against humanity must be an attack directed against a definitively identifiable civilian population. The prosecution argues that this attack was directed against suspected criminals and drug pushers. But legally speaking, does that group actually constitute a civilian population?
Of course it does. They are civilians.
But targeting a suspected criminal requires subjective discretion by the trigger puller on the street. There are no objective, permanent identifying features of a drug pusher. They don't wear a specific uniform.
No, but
They don't have a specific tattoo. It is a shifting, mutable, subjective concept. If we look at the precedents set in the Al-Hassan case and the Kenya situation at the ICC, the pretrial chambers ruled that random selection based on perceived, subjective characteristics cannot constitute an attack directed against a civilian population.
I understand that, but
If the definition of the target is left purely to the discretion of the police officer on the street, the targeting is inherently random, not systematic. Furthermore, the prosecution has failed to show the structural chain of command.
they presented a whole pyramid structure.
They presented a pyramid to the judges with Duterte at the top and the hitman at the bottom. But the apex of that pyramid is broken. They have absolutely no evidence of a direct order flowing from the top to the bottom for these specific incidents.
Calling the victims randomly selected completely ignores the crushing socioeconomic reality of who is actually being killed.
I'm not ignoring the reality. I'm talking about the legal definition.
But the victims overwhelmingly shared objective demographic features. They were drawn almost exclusively from the most impoverished, vulnerable urban settlements in the Philippines. This wasn't a random assortment of civilians. It was a highly targeted war on the urban poor.
Being poor isn't the legal definition of the targeted group, though.
The victims were people living hand-to-mouth in informal settlements, and the prosecution's framing is actually completely consistent with the Kenya precedent, where police violence targeted perceived gang members within specific, impoverished communities.
But the Kenya precedent required a much clearer structural link.
And the law supports it here. Article 7 of the Rome Statute only requires an attack directed against any civilian population. The law does not require them to be a protected ethnic or religious class like we see in genocide charges. They just have to be civilians targeted systematically.
And what about the broken apex of the pyramid?
As for the broken apex, this is exactly why the prosecution is pursuing charges under indirect co-perpetration. Duterte didn't need to pick up a phone and order a specific street-level hit in Manila.
But he has to give some sort of command.
He facilitated the entire apparatus by taking the key personnel who executed his Davao model, people like Ronald De La Rosa, and appointing them to national positions of power. He provided the budget, he established the operational quotas, and he publicly, repeatedly promised to assume full legal responsibility and pardon any officer who shot a civilian.
Wow.
He didn't just wink at the mafia. He built the machine, fueled it, and disabled the brakes. That is the very definition of a state policy to commit an attack.
But indirect co-perpetration isn't just a catch-all term for bad leadership. It still requires a mutually agreed-upon criminal common plan between the co-perpetrators. You have to prove legally that Duterte and his police chiefs literally sat down and agreed to a nationwide campaign of extrajudicial murder.
They aren't required to have a signed treaty.
No, but the prosecution openly admits they cannot point to a specific meeting where this criminal agreement took place. Instead, they ask the chamber to infer it entirely from circumstantial evidence, from his speeches, from his brash public persona, from the statistics.
Circumstantial evidence is valid in international law.
It is, but you have to understand how circumstantial evidence is evaluated. The cardinal rule of circumstantial evidence in criminal law is that the incriminating conclusion must be the only reasonable inference that can be drawn from the facts.
Okay.
If there is another reasonable explanation, the charges fail. If a president appoints a trusted police chief from his home city to lead a national crackdown on a severe violent narcotics epidemic and issues orders to neutralize armed cartels while explicitly in writing, telling them to follow the Constitution and act in self-defense.
Yeah, but
The far more reasonable inference is that he was trying to aggressively police a national crisis. He wasn't orchestrating a genocide. The fact that rogue elements or corrupt officers may have committed widespread abuses on the ground does not automatically mean the president of the country formed a criminal common plan to murder them.
let's unpack that only reasonable inference standard a bit. Because when you step back and look at the totality of the circumstances, when you look at how all these elements interact, the circumstantial evidence becomes completely overwhelming.
Overwhelming?
Yes, overwhelming. You don't need a signed contract reading, "We agree to commit murder," when the structural reality operates identically to one. Look at the timeline. We have 3 distinct periods: the mayoral period in Davao, the presidential campaign, and the national presidency. The pattern is unbroken.
The pattern of aggressive policing?
No, the pattern of killings. You have a leader who explicitly campaigns on killing 100,000 criminals and dumping them in Manila Bay. He takes power. He elevates the specific architect of his local operations to the national stage.
Right.
Suddenly, a minimum of 20,000 citizens die in police operations or vigilante killings under a program called Double Barrel. The state's Department of Justice ignores the mandatory circuit breaker investigations into those deaths. And the president publicly mocks human rights advocates and takes credit for the carnage, telling the police, "I will protect you."
Which is terrible optics, obviously.
It's more than optics. When you combine the public admissions, the structural shielding of the police, the Supreme Court's acknowledgement of the massive daily casualty rate, and the terrifying culture of impunity that paralyzed these communities, the evidence undeniably clears the threshold. It is the only reasonable inference. There are substantial grounds to believe a state policy of murder was enacted.
You're weaving a very compelling narrative, but I have to conclude that international criminal law demands a higher, more rigorous standard of proof. While the rhetoric was undeniably violent, crude, and deeply offensive to international sensibilities,
Extremely offensive.
and while the deaths of thousands of Filipinos is an absolute tragedy, we cannot legally conflate bad governance or even violently aggressive law enforcement with crimes against humanity. If we do, we lower the bar for international law everywhere.
I don't think holding leaders accountable lowers the bar.
But look at what we are left with. We are left with 35 exonerating speeches that specifically command lawful engagement. We are left with an utter lack of a direct causal order for the 49 charged incidents. We are left with a subjectively defined victim group that blurs the legal line between random police encounters and a systematic attack.
And we are left with national statistics of over 118,000 arrests that strongly suggest the police were, in fact, attempting to conduct standard law enforcement operations, not a systematic extermination. Without the hard physical proof connecting the top to the bottom, reasonable experts are left questioning if the strict legal criteria of the Rome Statute have truly been met.
This has been an incredibly rigorous legal stress test of the evidence, and I think it highlights exactly why these proceedings at the ICC are so vital. Understanding the precise legal boundaries between, aggressive domestic law enforcement, political demagoguery, and international crimes against humanity is crucial for the preservation of the rule of law globally. I agree entirely. The distance between a politician who speaks recklessly and a co-perpetrator of mass murder is measured in strict causality and hard evidence. It isn't just about what feels right. It's about what can be proven in a courtroom.
Absolutely.
I highly encourage our listeners to dive into the ICC transcripts themselves. Read the speeches, look at the operational parameters of Command Circular 16, and grapple with these profound legal questions on your own.
Because at the end of the day, when you are looking at a tragedy of this scale, the world deserves to understand exactly how the law evaluates the truth. Are we looking at a domestic crisis that violently spiraled out of control, or are we looking at the deliberate blueprints of a state-sponsored attack? We'll leave that for you to decide. Thank you for joining us on The Debate.
The confirmation of charges hearing in the case, the prosecutor versus Rodrigo Roa Duterte, took place from 23rd to 27th February 2026 before ICC Pretrial Chamber 1, composed of Presiding Judge Julia Antonella Motok, Judge Reine Adeline Sophie Alapini Gansu, and Judge Maria del Socorro Flores Liera. During the 4-day hearing, the prosecution, the defense, and the legal representatives of victims presented their opening statements. They made oral submissions before the judges on the merit of the case, and finally, they made their closing statements. The confirmation of charges hearings were held in the absence of the suspect, Mr. Rodrigo Roa Duterte, who was represented by his lead defense counsel, Mr. Nicholas Kaufman. The presiding judge, Judge Julia Motok, reminded the public as well as the parties and participants about the purpose of a confirmation of charges hearing.
La présence audience est relative à la confirmation des charges.
This hearing concerns the confirmation of charges by the prosecution against Mr. Duterte. At this stage of pretrial proceedings, the OTP alleges that Mr. Duterte is responsible for the crimes that the course officers shall read out shortly. The Chamber shall not take any decision with regard to the guilt or innocence of Mr. Duterte during this hearing. Indeed, the role of the Chamber is to determine whether there is sufficient evidence to establish substantial grounds to believe that Mr. Duterte committed the crimes with which he is charged. If all or part of the charges are confirmed, the Chamber will refer the case to trial, where the trial chamber will decide upon the innocence or guilt of Mr. Duterte. The general principles to be applied at the hearing are as follows. The suspect, in accordance with Article 66 of the Rome Statute, the suspect is considered to be innocent until his guilt has been proven.
Mr. Duterte is suspected of murder qualified as a crime against humanity allegedly committed in the Philippines between 1st November 2011 and 16th March 2019. During this time, Mr. Duterte was, at varying times, the president of the Philippines, the mayor of Davao City, and allegedly the head of the Davao Death Squad. During the confirmation of charges hearing, charges against Rodrigo Duterte were read out in the courtroom before the parties and participants took the floor to present their opening statements. For the prosecution, Deputy Prosecutor Niang presented the prosecution opening statements.
Today marks an important day for international justice for the people of the Philippines, for the victims, and for this court. The commencement of the confirmation hearing against Mr. Rodrigo Roa Duterte is a reminder of the court's unwavering commitment to its mission to investigate and prosecute individuals for the most serious crimes of concern to the international community and to bring justice to the thousands of victims of the mass crimes and atrocities perpetrated in the Philippines. It is also a reminder that those in power are not above the law.
During the submissions on the merit of the case, the prosecution team, led by senior trial lawyer Mr. Julian Nichols, further detailed the alleged crimes that were committed by Mr. Duterte during the charged period. Mr. Nichols presented prosecution evidence indicating Mr. Duterte's alleged responsibility in the alleged crimes during the relevant time period. Further, the prosecution alleges that Mr. Duterte played a pivotal role and he was at the heart of a common plan which was to neutralize alleged criminals in the Philippines. The prosecution presented videos, photographs, excerpts of witness statements, reports and documentation, among other evidence.
We're here today because the evidence shows, despite what we heard for the last 30 minutes before the break, that Mr. Duterte murdered thousands of his own people, Filipino men, women, and children. He was at the center of a common plan, which included the murder of alleged criminals throughout the Philippines. The plan was first implemented in Mr. Duterte's hometown of Davao. While mayor, he promised to clean up the city by killing alleged criminals. He kept that promise, and he murdered hundreds through so-called liquidation squads, death squads. These liquidation squads became notoriously known colloquially as the Davao Death Squad, or DDS.
The prosecution senior trial lawyer, Mr. Julian Nichols, further detailed the alleged crimes that Mr. Duterte committed.
As president, he murdered thousands using many of the same co-perpetrators and methods from his time as mayor of Davao. So he moved the method and some of the co-perpetrators to Manila in order to expand the crimes. The victims in this case ranged from powerful individuals to predominantly the poorest citizens of the Philippines. Now, why were the poor selected and victimized? Well, it was often because they were the most vulnerable. And they didn't have the families and the power to make police reports, and they were the most afraid. Mr. Duterte boasted about the killings that resulted in thousands of deaths at his order. And not once, at any time, has he shown any remorse. He promised, also, you will hear, to take responsibility, personal responsibility, for the killings, if need be. Well, that time has come. We are confident that if your honors confirm the charges in this case, that we will prevail and Mr. Duterte will be convicted at trial.
Mr. Joel Butuyang, the legal representatives of victims in this case, presented the opening statements on behalf of the victims.
Madam President, Your Honors, by way of an opening statement, we convey the views and concerns of the 497 victims authorized to participate in these proceedings. At the outset, Your Honors, we communicate the very deep disappointment of the victims at the decision allowing Rodrigo Duterte not to be present in this stage of confirmation of charges. The sight of Mr. Duterte being read and being confronted with the grave and horrible charges against him would have constituted a vital component of justice for the victims. This case symbolically represents the last boat that the victims can board to go on a journey in search of justice for their loved ones who were brutally killed upon the orders of Mr. Duterte. Your Honors, Mr. Duterte has been in detention here in The Hague for almost a year now, but there has been no peace and rest for the victims. From the time their loved ones were killed and continuously up to this time, they lived in constant fear for their lives. The arrest and detention of Mr. Duterte has not stopped impunity in the Philippines. The virus of impunity that he spread all over the country has become a cancer that has metastasized, infecting millions of Filipinos.
Further, Ms. Paulina Masida, legal representative of victims in this case, made submissions on the merit of the case. Ms. Machina noted that thousands of victims suffered harm in the Philippines due to the alleged actions of Mr. Duterte.
We speak today on behalf of thousands of victims and surviving families who have suffered immeasurable harm under the so-called anti-drug campaign conducted during the administration of the suspect, former President Rodrigo Roa Duterte. We speak for families who cannot be here, mothers who buried their sons, children who lost their parents, the spouses who now raise families alone, and communities that have lived for years under fear and silence and that continue to bear the consequences of violence that swept through their neighborhoods like a storm. These victims appear today before you not as mere statistics or distant figures or images in report as pictured yesterday by the defense, but as human beings whose rights under the Rome Statute have been violated in the most profound ways.
Lead Defense Counsel Mr. Nicholas Kaufman, during his opening statements, made submissions about his client, Mr. Rodrigo Roa Duterte, and the alleged crimes that he is charged with.
In any event, we're not gathered here today to judge a man on the basis of his coarse attitude or his vulgar language. This court has convened a confirmation hearing to verify whether substantial grounds exist to believe that Rodrigo Duterte, the People's President, together with various so-called co-perpetrators, over the years of his governance, devised a criminal policy of wholesale and wanton murder. And since we are in a court of law, it is worth stressing, although I should not have to, cases are decided on the basis of evidence, not supposition, not rumor, not spicy gossip, and certainly not on the basis of political rhetoric and bluster.
Following the opening statements, the presentation on the merit of the case, the parties and participants also presented their closing statements, starting with the prosecution. Mr. Julian Nichols, prosecution senior trial lawyer, requested the chamber to confirm the charges against the suspect, Mr. Duterte.
The facts can't be denied by these sprinklings. He ran a death squad in Davao that he created. He ran it for over 20 years before he became president. His promise was to kill thousands, and he did. So it doesn't matter how many times he tried to throw in a caveat. And again, as I said, this is not uncommon in crimes committed by powerful figures. They try to build in an offense. It's a quote from a speech on August 16th, 2017. What did he say? Quote, "I know I will have my own downfall. I cannot be president forever. I know that they will demand to answer for all this dead." End quote. And he was right when he spoke those words. He must answer for the dead. The victims demand it. Justice demands it. And for purposes of confirmation, the evidence demands it. We have proven it to the level for this to be bound over for trial. We ask you to do that, Your Honors.
Mr. Gilbert Andres, legal representatives of victims, made closing statements on behalf of victims in this case, requesting the chamber to confirm the charges against the suspect, Mr. Duterte.
The victims submit that the prosecution presented sufficient evidence to establish substantial grounds to believe that Mr. Rodrigo Roa Duterte committed each of the crimes charged. Consequently, all charges should be confirmed, and Mr. Rodrigo Roa Duterte committed to trial. Lastly, Your Honor, the victims want these charges to be confirmed because they want to be reintegrated to their communities, because they are still in the shadows of fake news, of fear and of threats from Mr. Duterte's supporters. Hence, it's important, Your Honor, that all of these charges be confirmed against Mr. Duterte so that the victims of these crimes will be taken out of the shadow of darkness into the light of truth and justice.
Finally, lead defense counsel, Mr. Nicholas Kaufman, made his closing statements whereby he requested the chamber not to confirm the charges against his client, Mr. Duterte.
Your Honours, it is so easy to choose as a target for prosecution a politician because of the way he presents his policies. If Rodrigo Duterte is to be faulted for anything, it is for his inappropriate choice of language. But he murdered no one. Out of that huge database of evidence on which the prosecution relies, I repeat that there is absolutely nothing to directly link Rodrigo Duterte to the 78 deaths alleged. That is why they rely on a few selective and vociferous individuals in the Duterte administration, calling them co-perpetrators, just so it can artificially superimpose their fantasy common plan theory linking Rodrigo Duterte to the victims. Your Honours, I beg you to be guided by evidence, which must reach a minimal level of integrity. Be persuaded by your own innate sense of justice and by your own collective years of experience. But most importantly, be guided by coherent evidence and by common sense. I ask you, I beg you not to confirm any of the charges. I ask you to let Rodrigo Duterte return to the Philippines, not to govern, but simply to let him live out the rest of his days in peace, in his humble dwelling in Davao.
Following the conclusion of the submissions from the parties and participants, the presiding judge thanked everyone before adjourning the hearings. The purpose of a confirmation of charges hearing is to determine whether there is sufficient evidence to establish substantial ground to believe that the person committed each of the crimes charged. If one or more of the charges are confirmed, the case will be transferred to a trial chamber, which will conduct the subsequent phase of the proceedings, the trial.